Wrongful death actions in Ohio are brought by an estate. That's why it's important to have an experienced lawyer who's experienced not only in personal injury cases and in wrongful death cases, it can handle probate matters. The probate is necessary because the decedent cannot bring a wrongful death case on its own. The estate, on behalf of the next of kin, needs to be opened, processed, and closed by the lawyer handling that case in order for you to recover. Additionally, the Ohio legislature has codified the wrongful death laws. They are in the Ohio Revised Code. Basically, the Ohio Revised Code gives a wrongful death plaintiff or an estate two causes of action. One, a survivorship cause of action for the damages sustained by the decedent before their death, for example, pain and suffering, funeral expenses, and medical expenses. And secondly, a wrongful death action for the next of kin, for the loss of the love, companionship, the emotional distress, and the loss of the loved one by the next of kin. The next of kin in Ohio is identified basically as the spouse, children, and the parent of the decedent. I can recall a case that I handled some years ago on the behalf of an individual who suffered a heart attack and was picked up by the emergency medical service, or EMS. During the EMS ride to the hospital, they did an EKG, and he, in fact, had a heart attack. He got to the hospital, the EMS gave him the EKG, but somehow the emergency room at the hospital lost it. The hospital medical providers, without the EKG, treated the patient for GERD's disease. Oftentimes, GERD's disease will mimic the symptoms of a heart attack. Unfortunately, the next day in the morning, the patient had another heart attack and died. Despite the patient's age, I was able to obtain a multi-million-dollar verdict for that spouse and the daughter who suffered a loss by reason of that individual's death.